Hello and welcome to Finance Conversation. This is the 45th episode of the Merging Life and Money Show, and I am delighted to be here today. For those of you who do not know me, I am your host, Marie-Jo César. I help professional women bridge the gap between life and money by acquiring and applying the relevant financial skills and knowledge they need to take control of their money, manage their finances, and understand that they can live their best life with the money they have. Thank you for joining in today. If you are watching the replay, make sure to type hashtag replay in the chat and leave me some comments and questions. Welcome, welcome, and welcome. I come to you live every Thursday at 5 p.m. Pacific Standard Time to share valuable information about how to acquire financial wellness and live your life with means and meaning. Well, 2022 is now in full swing. And my first question for the entrepreneurs and business owners who are or will be listening to the show is, when was the last time you review your existing business arrangements and legal requirements? And for those aspiring to become business owners in 2022, I will say that please ascertain that your business is set up properly and that you know your rights as a business owner. To help you with these matters, I have with me today none other but Michael Safren. Michael is a business lawyer from Washington State. Michael will help you understand the law as it relates to your small business. Michael, as I mentioned, is a business lawyer from Washington State. He focuses on helping people and businesses in three primary areas that are business, real estate, and probate. Michael guides business owners across different industries to select and form business entities. He advises business owners on the ever-changing state of the law and has developed strategies to help business owners save, in some cases, tens of thousands of dollars. He drafts contracts, service agreements, disclaimers, indemnification agreements, and terms and conditions of service for online businesses. When Michael is not in the office, he enjoys spending time with his family. He loves to cook. He likes watching football. And Michael also speaks Spanish. Welcome, Michael, to the Merging Life and Money Show. And welcome, followers and listeners. Thank you for joining in today. So grab a pen and a notebook, as you would want to take some notes and share them with family members, friends, colleagues, etc., because it is about sharing value that could benefit others. So let me start with a few disclaimers. Everything said in the Merging Life and Money Show is for general, informational, and educational purposes only, and is not intended to constitute legal, tax, accounting, or investment advice, and should not be relied on for tax, legal, or accounting advice. You should consult your own tax, legal, and accounting advisors before engaging in any transactions. Okay, so to give some context to the show, I will say that the small business economy is set to soar in 2022. And countless small business owners will be reviewing their setups, and thousands of them, I would say, prospective business owner will be launching their businesses. So starting your own business can be an equally scary and exciting time, because it is a time for making big decisions that can have a resonating impact on the success of your organization and on the course of your life. So arming yourself with the information you can get will help to ensure that you make the correct decisions and that you will be setting your business up for success. So today we will be focusing on 3 points. The type of business entities entrepreneurs can choose from, the 4Ds in business and why they are important, and last but not least, what is a contract, and does it have to be in writing? So before turning it over to Michael, I will say that a successful business starts with setting up a business entity. All right. So small business owners must decide what type of legal entity their business should become. So note that the type of legal entity you choose will have implications on everything from the taxes you need to pay to the amount you can be held liable your business action. So Michael, I'm getting off my soapbox now, and I have a few questions revolving around business entities. The first one is, what are the most common business types entrepreneurs can choose from?
Yes. Well, thank you. First, let me just say it's a pleasure to be here. Thank you for having me, and I'm happy to share information with all of your viewers and watchers and listeners. I would point out just very quickly, as you gave your disclaimer, this is not legal advice, and anything I say is for educational and entertainment purposes only, and that listening to me speak on this broadcast does not create an attorney or client relationship. Okay, got that out of the way. I really wouldn't be a good lawyer if I didn't say any of that. So the first thing I'd say is I'm here at home with my son, and he's making a little bit of noise, so I apologize for that. Business entities are important because they can, if the right business entity is selected, create a shield of liability that protects the owner of the business and the operator of the business from any business liabilities transferring over to their personal liabilities. What is a liability? It's basically just a legal obligation. You can have a legal obligation that arises from a number of different reasons. You could have a legal obligation that arises out of a contract or an agreement. So you might have signed something that says, hey, I have an obligation to pay you or repay you for a loan. You can have an obligation that arises out of law. Here's my little guy. I'm sorry. He's looking forward to being here on the show. You can have a contract. You can have an obligation that arises out of law. Let's say you do something that's you have an obligation to pay taxes, or you have an obligation to that arises out of operation of law. Like, for example, if you did something wrong and somebody sues you and they win and they get a judgment against you, then you have a legal obligation. And so what the value of a business entity is that it can create a separation between the business obligations and the business assets and your personal obligations and your personal assets. Boy, that was a mouthful. Okay. I really just said that to set the stage to say there's different kinds of entities. I'll be speaking from my knowledge of Washington law. Each state has its own set of law. A body of law based in statutes, which are passed by the legislature, and case law, which is law adopted and created through the court system. So here in Washington, the default position for any business, if you don't go and register it, is that of a sole proprietorship if you're operating by yourself, or if you're operating together with a spouse, or it would be a partnership if 2 or more people are engaging in business. There's another form of business entity called a limited liability company, which is quite popular as well. That form of entity creates a limitation of liability and is quite popular because there's a lot of flexibility. Another form of business entity is a partnership. That's where 2 people, as I said, are in business, are operating a business together. And another common form of business entity is that of a corporation. A corporation is basically a chartered or registered business entity that can operate and do business and has shareholders. Mm-hmm. And so one of the big distinctions between a limited liability company and a corporation is that in a corporation, the people who own the company are called shareholders, and they're governed by shareholder rights agreements, whereas if you have a limited liability company, those people own membership units, and they're considered members of the limited liability company.
Okay.
So hopefully that's a good rundown of some of the basic and more popular business entities.
So my next question that revolves around these various entities, you mentioned again corporations and limited liability companies, solopreneur, or even partnerships. So tell me, how do prospective entrepreneurs go about choosing the right entity for their business?
Yeah, that's a great question. As I said, it's got to be it's a specific decision to that entrepreneur or to those entrepreneurs as to what they anticipate the business is going to be, what sort of environment they're going to be operating in, and what sort of administrative and cost burden they're willing to shoulder. As I said, a partnership or a sole proprietorship are the default entities here in the state of Washington. Meaning, if you don't do anything more, if you don't register with the proper authorities for the state and get proper licensure and registration, you will be considered a partnership or a sole proprietorship, depending on how many people are working together, one or two or more. If you go through the process, each one of these different entities has different burdens, but also has different optionality. One of the advantages that a lot of people seek and find in a limited liability corporation is the flexibility in terms of taxation. As a sole proprietorship or as a partnership, you're going to be taxed as a sole proprietorship or a partnership. There's really no way around it. Right. When you're an LLC, a limited liability company, you have the option to choose basically from 3 taxable designations. The first is a pass-through entity, meaning the IRS doesn't recognize the entity as a separate entity for tax purposes only. We're not talking about liability purposes. We're talking about tax. The IRS simply sees through it. And so any income that you make is attributable at your marginal tax rate. This is really good if, again, you don't have a great deal of revenue, perhaps don't have any employees at this stage. So then passing it through might be very advantageous, again, based on your marginal tax rates and your taxable situation. On the other hand, a corporation, an LLC also has the option to be taxed as a S corporation or a C corporation. Again, an S corporation is an entity that has one class of shareholders and is taxed as again a pass-through. Is taxed as a pass-through entity, whereas a C corporation pays separate taxes. So a C corporation pays taxes twice. The first is it pays taxes on its business profits. The second time is if it distributes any dividends, retained earnings, or excess earnings or profits after taxes to its shareholders, the people that own the company. Those would then be considered taxable as well, and you would pay taxes on that. So it's basically taxed twice. And so depending on, again, how much revenue you're making, where, do you have multiple investors? Where are those investors located? Do you want to have different classes of shareholders? Meaning, do you want to have different voting rights or different privileges or rights or obligations for the different shareholders? Well, if you do, then maybe a C corporation is the way to go. You've got perhaps a number of investors. These investors want the assurances of holding some stock. You might want to set it up so that the shareholders maybe don't have the ability to outvote you. And so a C corporation might be the way to go. If you, again, maybe have employees, but don't have significant investors, maybe an S corp is the way to go. Because you can, again, pass through the earnings at your marginal tax rate, but because it's a separate entity and taxed separately, you can have employees and then pay yourself a reasonable salary, and then take the earnings out of the business at a rate where you don't have to pay the self-employment tax. So it just depends on the particular situation. That's something that we do a lot, is walk business owners through these sorts of questions and analysis and help them determine the appropriate business entity for them.
Thank you so much. I mean, I do really understand why it is necessary to have a proper understanding of what type of business you want to get into, because this could lead to some very technical consequences, as it relates to tax, the whole tax consequences, and of course, the relevant administrative burdens placed on the type of entities that one would choose. So, moving right along, thanks a lot, Michael, for that. Very valuable information. And hopefully, we'll get to summarize that somehow and offer that to the audience at one point. So, in previous conversations, you mentioned the 4Ds in business. Can you tell the audience what they are and why they are so important?
Certainly, yes. This inevitably comes up at some point. The 4Ds, which are death, disability, divorce, and disinterest. And the 4Ds are, unfortunately, just facts of life. We deal with them as business owners, but they can have a extreme impact on how our businesses operate. If you're a sole proprietorship, in the event of death or disability, or even disinterest meaning you don't want to run the business anymore, the resulting death or disability or disinterest basically just means you wind up the business, you pay off any creditors that might be, you sell off any assets that might exist, and you basically close up the shop. One of the problems is that you can't create an enduring legacy. So the business dies with you, right? If you become disabled, the business is gone. If you die, the business dies with you. If you don't want to operate the business anymore, there's no one to pass it to. You're just closing up the shop and walking away. This also creates additional complications at a divorce, because certain states are considered community property states. Washington, where I practice law and live, is one of them, meaning that the income and the assets that are acquired during the course of marriage are community assets, with a few exceptions. That means the business and the profits from the business are a community asset, and therefore the assets that the business may have acquired over time might be in part divided between two separating spouses by the court. So having a sole proprietorship really leaves you very vulnerable for these 4Ds, because again, you can't create a legacy, you can't pass things on in an effective manner, and again, divorce could basically force the closure or division of business assets, even if you as a business owner or operator aren't ready to do so. If you go and look at some of the other entities as well, it also creates problems. These 4Ds can create problems. Fortunately, there is some, at least in my state, there is some sort of basic laws that provide guidance to how to operate this, but generally isn't sufficient and doesn't provide, I think, adequately for business owners. So one of the things that we do is, when it comes to an LLC or to a corporation or to a partnership, is we look ahead and we figure out, hey, how can we help the business owner prepare for that? One of the tools that we use is, especially in a multi-member LLC or in a partnership or in a closely held corporation where there's only a handful of shareholders, is we look at creating or having buy-sell agreements in the event that someone says, hey, I don't want to be part of this anymore. And so the buy-sell agreement creates a mechanism for automatic sale when someone is disinterested, and creates a valuation mechanism, or at least a process for creating that valuation. Another mechanism for death or disability is insurance. You have an insurance policy that springs into effect if one of the key members passes on or becomes disabled. That gives that provides funding. That provides a funding mechanism for the buy-sell agreement, so that the remaining members or partners or shareholders can now have funds to use to buy out the interest of the shareholder or member or partner who has died or has become disabled and can't participate in the business, or is going through a divorce and wants to have those shares bought out so that they don't fall into the ex-spouse's hands and everyone finds himself in business with someone they never intended to be in business with. So there are steps that we can take, and I think working with an attorney that's versed in these areas and is knowledgeable is helpful, because we can again create these preemptive mechanisms that anticipate what happens when these inevitable life events occur, without letting them be so disruptive as to destroy or push the business back into a situation that it can't recover from, or business partners are forced to have a partner they didn't intend to have, or additional interest holders that they didn't want to have as part of the business.
Mm-hmm. Well, that is really great information, and I could tell you, when one decides to open up their own shop, they don't always think about all these potential issues that could come up. And as you said, what further complicates it is that all depends what state you are in, what state you live in. As you mentioned, in Washington, where you got a business and you're in a relationship, okay, it's a share situation. So you have to make sure that you have the logistic in place if any any of those 3Ds were to occur. So again, very very insightful, but lots of information, and again, I'm not sure with the amount of businesses that are born every day, and I'm not entirely sure that those business owners and future business owners even contemplate the complexity of setting up a business, and the consequences that ensue, really. So thank you for that, because they are not good situations, but it's good to know that there are ways of minimizing their impact. So continuing on, last but not least, let's talk about contracts. So how do they work, and can one do those contracts need to be in writing? And I'm saying that because it's a whole culture of coaches and stuff like that. People sign up with their programs, and some of them could be quite costly. And very often there are no sites of a contract. So could you explain to us, how contract works? I mean, is if you just tell me that you're going to provide a service and I give you my card to pay for it, is that a contract? I mean, tell me more about it. I can hear you. You're muted.
Sorry, it's a great question. The first thing that we have to understand is, in business, contracts are really the lifeblood, the currency of what we do, right? Because what a contract is just basically an agreement between two or more parties that that the parties will engage in some sort of mutual exchange. We call that mutual exchange of value consideration.
Wow.
And so every legal contract has to have parties with the capacity to enter into a contract. So I'll give you a visual example. Here's my little guy. He's a little too young to enter into a contract, right? Usually most states have, again, by their own rules, they have rules as to, how old do you have to be? What sort of capacity do you have to enter into a contract? So there's issues of capacity, but, putting those aside, I think the big thing is, do you have what's called a meeting of the minds? Do you have an agreement on the essential terms of what is to be exchanged and whose duties and obligations are, and what those duties and obligations are? Again, consideration can be anything of value. So it doesn't have to be money. I mean, usually, obviously, currency, money is the medium of exchange, but they don't necessarily have to be. They can be exchanges for other things. You can be a promise to do something, right? I'll wash your car if you paint my house, right? These agreements can be for anything. The court generally doesn't look at what is the value or the substance being exchanged, as long as there is some sort of exchange. They can even be a promise to do something. Like I said, you promise to wash my car, I promise to paint your house. It can be a promise not to do something. If you've ever heard me sing, promise not to sing, I think carries a lot of value. So, there's really no limitation on what can be exchanged. The whole concept here is that something of value must be exchanged between the two parties. So, so that's what a contract is. Does it have to be in writing? With the exception of a few instances governed by, goes back to old English times. It's called the Statute of Frauds. It was first, I think, promulgated in the 1500s. But states adopt the Statute of Frauds into their legal codes today to varying degrees. Most contracts don't have to be in writing. But just because it's not legally required to be in writing in most instances, doesn't mean it's a good idea not to have it in writing. Okay.
I'm glad that you mentioned that, because I have had to my more recently, since I've been in that entrepreneurial space, I have come across people who sign up with a coach or consultant, whatever it is, for a service, and they are not given any terms and condition specifically, and they want to come out of to terminate the relationship, and they are having a lot of issues with that, because they figure that, okay, I didn't sign anything, but you paid for it, so paying for a service in advance, is that considered a contract?
Yes, if there's a meeting of the minds that there's evidence that party A wanted party B to deliver a service, and essentially they agree on the key terms of that service, as long as it's provided, then there's there's evidence that as a contract is made. I would point out that, again, there are certain exemptions in the Statute of Frauds. The two big ones that I think would come up mostly and that are usable is, first is any contract that by its nature would be performed in more than a year. So if the contract was, hey, I'm going to cut your grass for the next 2 years. Well, then, by the Statute of Frauds, it needs to be in writing. Without that, there's no evidence that I'm obligated for it.
Okay.
Also, a lot of states have adopted what's called the UCC, the Uniform Commercial Code. And in the Uniform Commercial Code, there's also a provision that says generally any contract for goods sold, consumer goods sold for more than $500 has to be in writing. So it affects hard tangible goods. The performance of services is generally not governed by the UCC, when it comes to Statute of Frauds. But again, just because it's not required doesn't mean it's a good idea not to have it in writing. In fact, it's a terrible idea. One of the things we counsel people to do is to get things in writing all the time. Why? Because it creates clarity. If you're simply relying on memory, oh yeah, I remember we agreed to something some time ago. There can be conflicts in what you remember and who remembers what. The other thing that it creates is clarity, right? You can look at it and go, yeah, I remember pretty much, but do I remember this exactly? Here's what it says. The other thing is it discourages conflict, because everyone can go back and look at what's in writing and say, yep, no, that's exactly what it says, and here's what someone has to do, and here's when they have to do it. And so, we certainly advise everything to be in writing. One of the things that we counsel our clients on is having things like a document retention policy, so that any documents they produce or receive get held and retained for a period of time, so that, again, you can look back on the documents that were generated or retained, or received through your business, so that, again, you can always refer back to them to avoid conflicts and confusion and issues of who's got to do what and when do they have to do it.
Correct. Well, thank you so much, because I could tell you that is to me still a very gray area. Particularly in the coaching space, where service is not clearly defined and expectations are not met. Yet again, fee have been paid, and a client wants to get out of the contract, and it could become quite time consuming and quite expensive at the end of the day, to figure all that out. So again, Michael, this has been invaluable information that you have mentioned there in such a short time. Thank you so much. And I'm going to wind down some and sum it up, try to sum it up. So today we talked about the type of businesses or business entities that entrepreneur can choose from. We talked about the 4Ds in business and why they are important and why you should know how to mitigate them. And they are divorce, death, disability, and disinterest. We also talked about contracts and whether or not a contract has to be in writing in order to be valid. Okay, so I am going to leave you and the audience with these last thoughts. Okay, so small business law can cover a wide range of subjects and requirements. So when you start a small business, you need to understand all of your legal obligations, from employment law and tax requirements to how to set up the right entity for your business. Okay, I will also add that by hiring an attorney, you can protect your business in the long run and have peace of mind, as they will help ensure that all your contracts are legitimate and your business is operating legally. And regarding the 4Ds, I know that thinking about them can be unpleasant, but it is essential to address these issues, especially if a company has co-owners, right? So, as I would say to the audience, whatever you do, just be sure to put a plan in place so your business will continue to thrive even when you are no longer a part of it. Okay? So I'm going to stop here now, and thank you, Michael, for your awesome contribution today. And I'm looking forward to having you on the show as we continue to share valuable information about legal requirements for small businesses. So before I forget, could you tell the audience how to contact you if they wanted to? And
Absolutely.
I think I have a banner for you as well, so I'm going to run it.
Yes.
And,
no, I appreciate it. So if you're in the state of Washington, I'm only licensed to practice law in the state of Washington. And again, to clarify, I've only been speaking about law from the perspective of operating and doing business in the state of Washington. Again, I do want to clarify, different states may have different laws. And so, you're advised to consult with an attorney, tax advisor, business professionals in your state that are familiar with your state's particular laws. Many of these concepts do have carryover and they are similar from state to state. But again, we definitely urge you to check in with a professional in your state that's licensed and experienced in your state. So they can get in touch with me if you're in the state of Washington or operating a business in the state of Washington. You can visit us you can come to our website. We do a number of events. We share information through our regular postings. You can sign up for our newsletter. Our website is www.jennyjennylaw.com. You can call us on the telephone, phone number 206-859-5098, or you can email me or follow us on Facebook. We're at Facebook with Jenny Ling Law. follow us there, and you can email me at msafren@jennylinglaw.com. And I do look forward to hearing from anyone who has questions about their Washington business or is looking to get started in Washington.
Yeah. Again, thank you so very much, Michael, and I do appreciate that you operate from Washington. But I guess anyone could contact you, and I'm sure through your fraternity you will be able to direct any member of the audience accordingly. Again, thank you very much. And as my audience knows, I like to end the show with a quote. And today's quote is from Justice Sonia Sotomayor, and it reads, "Every lawyer, no matter whom they represent, is trying to help someone, whether it's a person, a corporation, a government entity, or a small or big business." To me, lawyering is the height of service, and being involved in this profession is a gift. So thank you again, Michael. So for more information about how to achieve financial wellness from the inside out and live a purposeful life with the money you have, join me next Thursday at 5 p.m. Pacific time, 6 p.m. Mountain time, 8 p.m. Eastern time, 9 p.m. Atlantic time for my Bermudian peeps, 10 a.m. Friday Brisbane for my Australian friends. And thank you for being here today on the Merging Life and Money Show. I am Marie-Jo César. I will be back again next week. Until then, continue merging life and money. Bye for now.